Good morning. You're Edwinia Johnson?
Yes, ma'am.
And Ms. Johnson was previously in court, entered pleas of guilty in all three of her cases. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes,
Are there any additions or corrections?
I'd just like to address one thing that Mr. Smith had a problem with. It's kind of a law of parties thing on the forgery, I think. And I'll ask my client to clear it up. Now, you're working for a home health care agency, is that correct? And
Answer yes or no, please.
And your client at the time had actually disposed of some personal banking checks, is that right?
Yes, and I took them. I misspoke. I meant to say I took the checks, and I knew that Adrian Hayward was going to cash them, so I'm just as guilty as him.
So, and she said in here that she's the one who took them.
Yeah.
So I'm okay with that.
Brought it up, and
Okay.
I had to make sure about culpability.
I appreciate that. Yeah, I agree.
They've never caught AJ.
No, I've been hearing that he's incarcerated or whatever, but I haven't.
Okay. Any other issues?
No.
So I would like to know, just so that I know what, if any, conditions, what is the status of children? Where are they? Who are they with?
They're in foster care right now. They wanted Judge Shetson, I think this is his name. He wanted the restrictions of the probation so he'll know how to move forward. But I went to court the 16th for them, and they was trying to dismiss him, but I didn't have paperwork on probation.
Okay. What?
Speaking with Deborah's story, that typically, as a condition of the criminal case, sometimes they put some of the, won't abandon and get some of the CPS rules. I didn't see that.
Well, I guess I want to know what the status of, is CPS still involved? Is there a plan in place right now, an emergency?
I spoke with the CPS caseworker, and they wanted to know how these criminal cases were going to resolve. The plan's always been reunification. She's done real well with them, according to her, the caseworker.
So I guess what I'm going to need is, or probation's going to need is, my ruling's going to be that there's no unsupervised visitation unless she's followed through with all of the CPS plan. And so, and that's pretty much what the PSI says, is that their recommendation is no unsupervised contact without authorization from CPS. So if you're doing everything you're supposed to with CPS, and
we can go talk to Judge Shelton maybe, or no, this is fine.
No, I mean, that's as long as but she's going to have to give her probation officer documentation from CPS. So you can work that out with your probation officer. So mine's going to be no unsupervised unless, and then if probation gets that information and she's doing her safety plan and everything, then we're going to be okay with that here also. But they're going to kind of be the ones that dictate that process, not me.
Just kind of nebulous. A couple conversations with appointed counsel on that, and a couple conversations with the caseworker.
Okay. All right. So, Ms. Johnson. Ms. Johnson, in cause number 24 DCCR 2151, I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings in that case for a period of 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 24 DCCR 2152, also find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. You're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. And then finally, in cause number 24 DCCR 2153, find sufficient evidence to find you guilty. However, I'm again going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. There is not a fine in that case, and again, you're ordered to follow all of the rules and conditions of probation. One of the rules and conditions is that you have no unsupervised contact with any child, including your own, under the age of 18, unless CPS says that that's part of the plan and that's where they're working. And once they do that, if they do, you have to get that information to probation. So you can't just say, okay, CPS let me do it and I'm going to start seeing them unsupervised, because we won't know that you have that permission from them. Does that make sense?
Yes,
So you've got to make sure and go talk to your probation officer, make sure they know everything that's going on. And so part of your probation is that you are required to comply with all the conditions that CPS is imposing. So if there's still any classes you have to do, whatever it is, that's now also part of your probation. Does that make sense? So if you do everything that you're supposed to while you're on these probations, then this is an excellent opportunity because you don't have the felony convictions on your record. And at the end of the probation, if you do everything that you're supposed to, then the cases will actually be dismissed and you'll never be a convicted felon. The other side to that, though, is that if you violate any condition of probation, you can be brought back into court. You can be found guilty of each of the offenses. In that forgery case, you could be sentenced between 2 years and up to 10 years. And in those injury to a child cases, you could get up to 2 years in a state jail prison. Do you understand? In all of those cases, I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over all of your paperwork. All right, good luck to you, ma'am. Thank you, Mr. Frazier.
You can feel the tension here. Notice how Edwania admits guilt without excuses. That's rare in legal terms. That's taking responsibility early, and judges do remember that when deciding sentencing.
All right, sir, you're James Rucker.
Yes, ma'am.
And Mr. Rucker, in cause number 24, DCCR 1348, is charged with violations relating to hazardous waste and it's a third.
Mark Garcia.
The punishment range is that of a third-degree felony in that one, which is between, if you're found guilty, between 2 years and up to 10 years in prison. Do you understand? And then in cause number 24, DCCR 1349, you're charged with theft of property. Which is a state jail felony, and that's from May 18th of 2022. And then what that means is if you get found guilty in that case, the range of punishments between 6 months and up to 2 years in a state jail prison. Do you understand? In each of these cases, I have plea bargain rejections here with your signature on them and Mr. Galmore's that shows that the district attorney's office has made offers if you wanted to enter a plea of guilty in your cases. In the violation of relating to hazardous waste, they've offered, it looks like, is that a 6?
Oh, no, I didn't put the year, sorry, Judge. It was short.
Calmore.
The deal was for a short term of deferred.
So it's for a deferred probation that would be up to me, and I guess, which is obviously you've gone over with Mr. Galmore, type of probation where you don't have a felony conviction on your record. And then, is it the same in the other case? So you would be, if you wanted to plead guilty, it would be deferred probations in each of those cases with the term and how long that probation is up to me with input from everyone, of course. You have every right to reject those offers and have both of your cases set for trial. I do want to make sure you understand that what your possible consequences are if you go to trial, what your options are if you wanted to enter into those agreements. And do you understand all of that? And do you want to reject those agreements and have your case set, both cases set for trial? All right. And is there any reason, I mean, obviously, I can't imagine that the offer would get better. Ms. Malfino?
It's Mr. Shearer's case, Judge. I don't have any reason to believe that offer would change. I know they've discussed it for quite some time. I'll
Yes.
make sure if it's on the trial docket that it's prepared.
So I do typically make sure, unless there is new evidence that comes up that either Mr. Galmore or Mr. Shearer does not know about, or something has changed, I will not accept these plea agreements after today. And so if you change your mind later and want to enter a plea of guilty, it would be to some other plea agreement or open to the court or something like that. Do you understand?
Judge, just for the court's perspective, this case had a restitution in the amount of approximately $100,000. That's been reduced to approximately $13,000 now that those financials have been sorted correctly.
Okay.
I believe this is a situation where it will either require trial or it would be dismissed for restitution.
Okay, so not a restitution paid out over probation. Okay, all right, then obviously if that happens before, then the cases get dismissed, and that's another way for them to get off the trial docket, but other than that, we'll let a jury decide. All right, you're free to go. I'll set it on the trial docket. Thank you. Good morning, sir. You're Norbert Freeland Jr. And Mr. Freelo is charged with murder, and Mr. Galmore, Mr. Nichols, what's the announcement?
Judge, I don't think we're ready to set this for trial yet. I know it seems like every hearing I tell you there's stuff we need to investigate and find out, and there is still in this case. There's a potential witness who has given unsworn statements that is.
This part is huge. When the judge ties CPS compliance to probation, it means Edwania's freedom depends not just on obeying the law, but on proving she's a fit mother. That's double accountability, emotional and legal.
Basically blowing off appointments to give a sworn statement, and we need to run her down.
That's what we were gonna do last time.
And they made appointments, and she didn't show up.
Well, if we're talking about that one witness, she did meet with the investigators between.
Okay.
But there's also a new witness, another witness.
Okay.
And possibly some video footage that was deleted that I believe that Port Arthur Police Department is trying to get their hands on.
Yeah, I need to check the status of the subpoena for that video. We need a little more time to it.
Okay, all right, we'll just do a normal reset. Y'all can work on that. We'll see where we are at the next court date. Mr. Freelow, make sure you stay in touch with, did you have something
Yeah,
else?
I could, yes, Judge. I don't have a motion necessarily on file, but Mr. Freelow currently is on house arrest with a GPS device. His wife has recently been unable to return to work to the federal prison, so their income is limited. He's trying to find a job. It's been difficult, obviously, with the thing hanging off of your ankle and whatnot. So we were asking the court if the court would consider removing him from house arrest and GPS requirement.
No to both of those things, but potentially to, the GPS is going to remain on. I would consider, Mr. Nichols, what's your position with regard to him looking for work and getting a job?
I'm in favor of that, Judge, but I agree with the court. I think the monitoring needs to stay in.
For now, at least,
Monitor removing from house arrest?
Mm-hmm.
Okay.
Yeah. Wear long pants and cover it up, whatever you need to do. But at this point, I'm not willing to do that based on obviously the nature of the offense. And so if you do this, Mr. Galmore, if you'll just send maybe a memo over and copy Mr. Nichols on it so that I have a paper trail to say that you asked me and that I granted that part of it, and I'll just sign off on a memo. Doesn't need to be a motion.
We'll do
But that'll just remind me to get it in the file so that it's clear. Also, we can send that to whoever has his GPS monitoring device so they know it's just for work-related purposes. You can go find a job, go to work, things like that, but it's not just a full-on go do whatever you want kind of
Well, Judge,
release.
actually, that's currently the status. He is allowed to leave only for work purposes. Currently.
Okay.
But because his wife is unable to work, her medical conditions made it much more difficult for them. So if the court would still consider just removing him from house arrest and keep the GPS, that would probably help a lot with the other life's necessities.
Okay. I know you've asked for him to drive her to this. There's been doctors.
He was at the airport the other day. But I mean, obviously in life, a lot of things like that pop up regularly, and if he's going to wear a GPS device, the court will always know where he's at. That's important. But removing him from house arrest would be probably a big help.
Mr. Nichols?
Hard for me to really argue with that reasoning, Your Honor.
Okay, so I am going to require for you to remain in Jefferson County without permission. So if something happens, like the other day with the trip to airport or whatever, get with Mr. Galmore, he'll send me something, I'll approve or not approve. In Jefferson County, do what you need to live your life. I don't want, that doesn't include going to bars or going out at night
Maybe
or.
curfew is appropriate, Your Honor.
All right, here's the big reveal, the legal turning point. Watch this closely, because what sounds like mercy is actually a test in disguise.
Unless,
Yeah, that would be.
if he ends up with a night job, obviously that's different, but.
So let's do this for now. Let's make I'll release the house arrest, remain in Jefferson County with the curfew 8 p.m. to 6 a.m. If you get a job that interferes with, just get with Mr. Galmore and get those hours, whatever the job is, and we'll work around that. But primarily, I want you doing necessities away from your home, and that's it at this point, okay? All right,
Judge.
thank you.
Thank you, Your Honor.
And just like that emotional relief turns into legal suspense, the next case brings the courtroom from redemption to murder. It's a full emotional reset, and the tone shift is instant.